First of all, let me welcome all the guests for the opportunity to talk about very current issues in competition law. Actually, it goes beyond competition law because questions about platform industries are all over the newspapers today. So maybe my suggestion is that we will start off with a discussion, and towards the end, probably we'll leave about 15-20 minutes for Q&A so that there's a more lively back and forth between us and the audience. Will that be okay? All right. So maybe I just start off with firing a question, just to put the discussion in a more concrete setting. Maybe I think it's useful to see what are the cases involving multi-party platforms that had occurred in different jurisdictions, and then from those concrete examples, we could kind of further explore the relevant legal and economic issues and questions about enforcement. So maybe can the panel members kind of enlighten us with some examples about actual cases involving multi-party platforms?
Thank you very much. My name is Sadaaki, SUWAZONO, Deputy Secretary General, Japan Fair Trade Commission. I'm only enforcer around this panel also. Thank you so much. I'm privileged to say something first as a first speaker. And before answering the question, I'd like to say thank you to Hong Kong University, Lingnan University, and Florida University, and also a special thanks to Daniel. Here is Daniel. Okay. Anyway, I'd like to say thank you to all of the universities and guys. And also, I think that I fully respect to this initiative because, you know, this year's G7 summit, which was held by French presidency, which discussed about this issue, digital economy and competition. Maybe this is the first time they talk about the competition policy in the G7 summit. And also, now that under the strong leadership of the French concurrence of the authority of the concurrence, G7 competition authorities are now preparing for a statement for a common understanding about how to address this issue, including a platform business. So that's why this is a very one of the hottest topics in this competition community, I think. And also, we JFTC made a number of investigations about a big part of business like Amazon and Airbnb and also Apple and also other Japanese domestic big businesses, big platform businesses like DNA and also pet online business. So we have a number of facing a number of challenging issues. Because, you know, later on I'll talk about what kind of topics we are facing or something like that. First of all, I'd like to quickly talk about the Amazon cases and other cases. You know, in Amazon cases, JFTC investigated this company because it imposed so-called price parity clauses and selection parity clauses. That is a so-called most favored nation clauses on sellers of Amazon Marketplace in the contracts with sellers. And of course, you know, some of the critics say that it's very pro-competitive for consumers. But sometimes if the, you know, very influential huge market power companies may impose a MFN clause on retailers, then they will harm the competition in the marketplace. All over the marketplace of the retail sector. So that's why we started investigation, Amazon. But Amazon, as you know, that reported to EU Digicom, but also to JFTC, but we stopped our strategy of the MFN clause. So that's why we stopped the investigation. It's a so-called commitment type enforcement decision. So we stopped that kind of things. But anyway, maybe, you know, the MF clause should be treated very carefully by enforcers. This is a very first example. And also, we started an investigation last year for website, or Minna Pet Online. This is a Japanese operator which operates websites for matching the buying and selling of dogs and cats between breeders and consumers. And it's very, the typical exclusionary conduct. It's a kind of Google case. This website, very influential and for both breeders and consumers, and it provided a privilege to the breeders, especially very privileged breeders, about the kind of special treatment. If you stop the posting on other platform, then we will give you a preferential treatment about the top search queries about customers' search results. It's a very typical strategy for a big platform business. If you stop that other platform business contracts, then we'll give you a preferential treatment or lower listing fee or something like that. So it's a kind of exclusionary conduct. So then JFTC also started the investigation. But again, this online service stopped their business model. So we totally stopped that kind of preferential treatment of some of the privileged breeders. So that's why we stopped that kind of things. And also, we started last year Airbnb, which also make a special treatment for some of the lodging services. Again, this Airbnb platform business in Japan also reported to JFTC. We stopped this business model. So we stopped investigation. Of course, some of the other critics say that the JFTC should further make an investigation and impose a huge sanction like EU DGCOM. Of course, it's another option. But we experienced that in some cases during our investigation, big device companies withdraw the operation in Japanese market. We experienced that several cases. So that's why we emphasize to restore the competition as faster as possible. So that's why we stopped the investigation, and we emphasize to restore the market order for consumers. That's our choice. Maybe later on I'll explain that and talk about this kind. I'll stop here. Thank you very much.
I'm Alex OKULIAR. I'm a partner at Orrick in Washington, D.C. I am not a current enforcer, but I'm proud to say I used to be. I used to work at the Federal Trade Commission, and before that I worked at the DOJ Antitrust Division. So I'll follow up on the initial remarks by saying that the times are very interesting in the United States with respect to enforcement of multi-sided platforms. It is a big policy issue in the U.S., including up to the level of the presidential elections. We have candidates that are running for office that talk about breaking up large technology companies, separating platforms from underlying or related ancillary businesses. And it's something that, from time to time in my career, I've seen people talk about antitrust. I've seen it make headlines. But it's something that right now is at the forefront of, seems like, almost every debate in the U.S., including at the presidential level. And it's definitely something that's being debated among policymakers and enforcers below the presidential level, including at the different agencies in the U.S. The debate is taking place both domestically and also in international fora. There's been a lot of discussion at the OECD with respect to how to handle multilateral platforms from an enforcement perspective. There's been discussions about moving beyond antitrust, and some enforcers have submitted that there are market failures out there that are associated with certain platforms, and I think the issue has primarily been focused on attention platforms these days, so that's search engines or social media platforms. And the question is whether there are market failures out there that need to be regulated, right? And whether the regulation needs to maybe involve a separation of the platforms apart from ancillary businesses so that there isn't self-preferential conduct or other types of exclusionary conduct, or whether there needs to be regulation associated with the data that is fed into and also generated by these different platforms. And again, the focus of most of the debates is on attention platforms. Turning just to the United States, there's been a lot of development within the law. So historically, federal enforcers and courts would look to the interdependence of demand on either side of a platform in evaluating whether there might be harm to competition. And that's whether it was in a merger case or in a conduct case, they would look at both sides of the platform. But to make a case, they would typically look at and define relevant markets on either side of the platform and then make a case on that basis. Okay, so when I was at the FTC, we looked at Zillow and Trulia, which was a merger of two online real estate platforms. Part of the issue there was whether there was a separate relevant market that could be defined just around the online platforms. The commission concluded that there was not. And then a big piece of the analysis was whether or not there were alternatives for consumers and for advertisers on either side of the platform, such that the merger of these two platforms would create any competitive harm, or whether there were enough substitutes that there would be no competitive harm despite this merger. The commission, again, decided not to act, concluded that there wouldn't be harm on either side of this platform. That now has been called into question, that type of analysis, by the recent Ohio v. Amex case. And this is a Supreme Court case. I see a lot of heads nodding, so I think people are very familiar with it. And so I'll just say at a very high level that, you know, in that case, when it made its way up to the Supreme Court, the court looked at the level of interdependence across the platform and focused on this notion that for a transactional platform, like in Amex, like with a payment system, that the platform itself was going to be the market and the product was going to be the transaction, right? And that type of a bright line test, that type of a bright line rule really hasn't existed until this case. And so now the big issue, and I'll stop here, for enforcers in the U.S. is how broadly that Amex decision should be interpreted and what kind of platform should be swept within the Amex analysis. So does it include, exchange platforms? Does it include, again, I mentioned attention platforms. Should it include those? Does it include other kinds of platforms? And the distinction as between these platforms, I think, is going to ultimately resolve to how strong are the cross-platform network effects on these various platforms. And the stronger they are, the more likely it is that Amex applies. The weaker they are, the less likely it is that Amex applies. So I think those are the key questions that people are dealing with in the U.S. And I will now turn it over to others. Thanks.
You know, I just want to echo what Alex just mentioned. In the U.S., as a practitioner, we pay a lot of attention to what the court is saying in its opinion in the various high-profile platform-related cases. So, you know, it's, as Alex pointed out, there's this bright line kind of definitional bucket of transactional platform versus non-transactional platform. But in fact, I think the line is not that bright. It's, I think a lot of the business models can probably be categorized either ways. So from a practitioner, economist perspective, when we do economic analysis, the questions we want to ask is, what is the appropriate definition and what is the appropriate analysis that we should be doing to make sure that we are taking into account basically the full picture of the competitive pressure. What are the competitive forces that disciplining each of the platform that under investigation? So I think that's, to me, I think a lot of the framework, the questions that we're asking in economic analysis, in enforcement cases, remain the same. It's just with the complexity of some of the business models these days associated with multi-sided platforms, the tools needs to be tweaked, needs to be adjusted to appropriately address the various nuances that are introduced by the platforms. And before I kind of hand to my next panelist, I also want to point it out that, you know, in Europe, we've seen Google being investigated on a lot of different fronts, and they're being fined. So I think that maybe the philosophy is if you're big, you seemingly have a dominant position, you probably is more likely to do something bad. So they're being scrutinized a lot more than some other kind of business. And platform in a sense. Successful platforms require the size, the economy of scope, and the economy of scale. So they tend to be big. So I think that's probably also part of the reason why they get a lot of enforcement actions against this businesses.
Thank you. My name is Youngjin at Chang. Korea is not an exception. In the United States and elsewhere, people are talking about the platform economy, multi-sided platforms, and the issues associated with the potential abusive acts of the platform-based companies. The Korean government, when they came into office, this liberal, slanted government, they're emphasizing the fair economy and the innovative economy. So they are trying to enforce the Korean competition law as aggressively as possible. So the Airbnb and Booking.com and Facebook and then all the other major global platform-based companies, they are under investigation. And then some of them were penalized already, and then others are under investigations. In Japan's example, some of the companies were investigated by the competition authorities, but in Korea, we are using different tools. For example, in other jurisdictions, they are resorting to a traditional competition law foundation. We have that, but Korean competition law is administrating, on top of a Korean competition law, they are administrating dozens of other sister legislations. For example, a standardized contract act, that is very much a paternalistic piece of legislation being administered by the KFTC. So, in the case of Booking.com, in the case of Facebook, in the case of Airbnb, they all resorted to the standardized contract act. So, for example, in the case of Booking.com, they, from their website, just like in any other online travel agent, OTA companies, they actually provided the product, marked with a non-cancellation. So obviously, if you opt for non-cancellation product, then the price of the product will be substantially cheaper than the regular product, right? So in a way, the product marked with non-cancellation from consumers' perspective, after careful calculation of various options, they decide to opt for non-cancellation product to reduce the cost for their travel. But the KFTC, act on it, based on the Standardized Contract Act. They made recommendations to, Booking.com to delete the non-cancellation product category from their website. So, they issued recommendations not only Booking.com to, many other companies. So the recommended action by the KFTC is not really enhance the welfare of consumers. It's fairly paternalistic. From antitrust perspective, actually you are deprived of the right to entertain or enjoy much cheaper product. So, this is actually based on the concept of fairness. In Korea's competition law, just like in Japan, you have, abuse of superior bargaining position, which is different from abuse of market dominance. So I'll stop here, but there are many interesting issues we can discuss.
Well, good morning, and thank you very much to all the speakers for the wonderful contribution to the first question even with just the first question, you feel like there's so much that's already opening up in terms of the hotness of this topic, shall we say. It's hot for many different reasons, and I think one of the reasons is definitely that there's very much a sense that big requires examination. Yes. So I'm a competition counsel at Google, and I should just preface that anything I say here today are my personal views, so please do not attribute to the company. But it's fascinating to be on the same platform with enforcers, ex-enforcers, and current practitioners. I feel there's much richness to be learned today. So there were just a few very interesting points coming out. So in terms of multi-sided platform enforcement issues, it's clear that the nature of these platforms, they are constantly expanding and growing. So there's no one term that can neatly capture all such platforms at the present time. And as Youngjin was sharing, and Sadaaki as well, that there are instruments, tools available to regulators beyond traditional competition tools, and that certainly increases the complexity and also challenges for both enforcers, companies, and their advisors. So for this next question, I would like to invite the panelists to share with us what challenges they see from their perspective in this new economy.
Yeah, thank you very much. I'd like to just echo Auraellia. I'm a government officer, but my opinion and comment is not reflecting JFTC's official standpoint. Of course, based on our experience, JFTC experience, I'll talk about that. My comment, but it's not JFTC's official comment. But anyway, it's a very good question about we are now facing the very challenging issues of as a competition enforcers. I think that I'd like to emphasize on that, we competition authorities are now thinking about we need just our existing tool. We don't need a brand new tool for competition enforcement. I think that the Anti-Monopoly Act or competition law is a very flexible, responding to a very challenging competitive environment. The new competitive environment. I think that our experience of the enforcement against the big IT business dates back to 1998, which is the first case of the Microsoft case. But I think that we found that of course the existing tool can be applied to new platform businesses. But I think that there are two things we should keep in mind. One thing is that the speed. Their business is very, highly speedy, affecting to the other victimized companies or competition. In 20 years ago, that we faced complaints about Microsoft's conduct, which has just a single network effect. Platform business has a two-sided market and network effect, so it's different from the Microsoft case. But it took 2 years for our investigation. But during our investigation, that victimized company, which is a Japanese word processor software company, which product is more preferred by consumers than Microsoft Word software. But so competition in merit, that this word processor company has a very distinguished, very good software products. But Microsoft utilized the tying strategy with other platform type software. That's why that company withdrew from the Japanese market because of that. But of course, JFTC has investigated this company, this Microsoft conduct, but it was too late. It's just my personal opinion. It's not JFTC comment, but anyway. So, and also 10 years ago, we faced the first platform business case. This is a game platform business, game platform online. And again, this company's name is DNA, adopted that preferential treatment for some of the famous game providing companies. And if you stop that contract with other game platform business, then I will give you a preferential treatment if the consumers make a search query result, then that your game will be top ranking in the search results. So it's always typical strategy for a game platform business. Then that it took just a few months since that this strategy started, took the huge effect on the other game platform businesses. So that's why the JFTC started the investigation very quickly. So it took just 6 months to make a conclusion of our investigation. And we quickly made a cease and desist order against the DNA, which is a very influential game provider. But anyway, speedy is a very influential terms of the investigation. And also, platform business can utilize artificial intelligence for very effectively, very accurately. They analyze that all of the data very effectively. So that's why the Amazon's MFN clause will be conducted by very effectively, very accurately. So that's why, competition authorities should care about these strategies very, more and more closely. So that's why it's a very different from. So theoretically, there is nothing new in this strategy of the platform business or network effect, but effective and accurately and speedy. So that kind of factor is totally different from the other traditional industry. That's my impression. Thank you.
So I guess I'll follow. Thank you. So I have there are a lot of challenges that I think enforcers are going to face going forward. Thankfully, I'm not an enforcer anymore, but I'll give you 4 that I think are probably top of mind at the FTC and the DOJ and maybe other jurisdictions as well. So first, I alluded to the different types of platforms that are out there. And I think one of the things that enforcers and policymakers are going to have to do at the outset is to come up with a pretty good taxonomy of the different platforms. Now, there have been some attempts at this already. If you go again and take a look at the OECD, they have a recent paper that discusses different types of platforms. AAG, Makindel Rahim, also talked about different types of platforms in a recent speech. And the breakdown, at least thus far that I can see in terms of the big categories, you've got transaction type platforms that are similar to payment systems like American Express in that case. And so those types of platforms have very high levels of cross-platform network effects. There's real interdependence of demand on both sides of that platform or on all sides of the platform if there's more than 2 sides. Those types of platforms most likely should fall under an Amex type analysis. The next kind are exchange platforms. So that would be like like an eBay or something where you're going to barter or like a marketplace to purchase a good or service. Again, those also exhibit strong cross-platform network effects, but I think arguably not quite as strong as a payment system where you've already got 2 parties that are agreeing to transact, right? So there's a stronger network effect for the transaction system. But then arguably, those exchange platforms might fall under Amex, but again, I'll leave it to the enforcers to sort of sort that out where those end up standing. Attention platforms I mentioned earlier, that's another kind of platform that's out there. Again, that's search engines, social media, and the like. They exhibit strong cross-platform network effects. If you have a decline in usership on one side, you definitely are going to see a reduction in usership on the other side of those platforms. Again, not quite as strong as as a transaction system, although some of them now are migrating into transaction systems, as we've seen in the news recently. So there, again, maybe Amex should apply. But there are other features of those platforms that also should be taken into account because they have a relatively unique monetization model, right? Their model is not to charge for the transaction as you might see in an exchange platform or in a transactional platform. They actually will monetize by selling viewership to an advertiser, right, to a third party. And that's how they monetize. But there's still direct monetization there of a 2-party engagement or multi-party engagement. Another type of platform that is very dissimilar, I think, from the others is like a cloud or a software platform, right? There you have sort of fee for service, right? You don't have the same degree of network effects, cross-platform network effects that you see in the first 3. And there are many other kinds of different types of platforms. And again, I would commend you to look at the OECD paper because they walk through a number of different types of platforms. So that's the first set of challenges for, I think, enforcers these days. Another one is how to deal with zero price strategy on some of these platforms. How do you define a relevant market when one side of the market is effectively getting it for free, at least zero price? They're giving up other things in exchange. Megan Delrahim suggested that you look to other elements of competition. So you look to non-price elements like quality or choice or levels of innovation. I can tell you that from my own experience at the agencies, that always is taken into account, but it's very difficult, of course, to quantify those things. They're very subjective. And that makes for more difficult enforcement, less predictable enforcement potentially, unless you can create some bright lines. Another one is data. How do you deal with data? And I would suggest that there you take a look at who owns or controls the data, right? If you have someone that owns or controls data, there's a possibility that they could use that data as a barrier to entry, or they could use that data to enact a foreclosure strategy. Someone that is merely a data processor, like a piece of software, where you're just entering data into the software, and it's processing it but doesn't actually control the data, it's less likely in those circumstances that you might have a competitive problem. You also need to look at whether the data might be an input into another product or service, and whether, if it is an input, whether it's a unique input or they're reasonable substitutes. Because again, you could have a foreclosure issue there. So that's a third set of challenges to deal with. And I would say that for data issues, and actually I think for most of these, traditional tools of antitrust, generally speaking, are going to be able to take care of the issue. They're going to allow for effective enforcement. The agencies, for example, with data, they have a lot of experience dealing with data markets, defining data markets. There's an action by the DOJ about 10, 11 years ago in the merger of Thomson Reuters, where the DOJ actually went and defined a relevant market around financial data that was used by financial analysts. And they looked very carefully at the type of data that's being gathered, how difficult it is to gather that data, and concluded that the data sets being gathered by Thomson and Reuters for purposes of financial analysis were very unique. There were high barriers to entry, and as a consequence, they forced a divestiture in that deal because there was overlap there. And then finally, and I think very quickly, I'll say the last one to think about that's going to present a challenge for enforcers is going to be sort of behavioral issues and thinking about consumer behavior vis-a-vis platforms. So, for example, things like the tendency for consumers to single home instead of multi-homing. Now, I just cite that as an example, but agencies will have to be thinking about those issues and studying whether or not single homing, for example, as a phenomenon is true. And if it is true, how relevant is that for the competitive analysis? So why don't I stop there? Thank you.
Alex just mentioned single homing versus multi-homing, so I think maybe I'll start from there. I think it's definitely quite relevant when you want to look at market power. On surface, you would think, well, if the platform on one side has the user single homing, then you want to look at that side very carefully because they are really competing to get those customers. And on the other side of the platform, if the users are multi-homing, if the platform does something wrong, they could always leave. But I think it's probably more nuanced than that. You want to ask, when people multi-home, are they really multi-homing, and why are they multi-homing, right? Some people probably it's related to product differentiation. If something, they use different platforms for different things, just like the search sites. People might want to search certain contents on one site and search other contents on a different site. So really, when one platform, there's certain kind of conduct that is being implemented by the platform, you want to ask, okay, is the competition from other platforms really a disciplinary factor on the at-issue platform? I think that's one thing that I thought it's unique in the sense related to the multi-sided platform. And another thing is, I think Alex also alluded to it, is measurement issue. When you're dealing with the zero pricing strategy, there are a whole host of issues coming up in terms of how to do your traditional economic analysis. For example, the hypothetical monopolist test. How do you do that? And in that circumstances, you probably want to focus a bit more on the quality, innovation, consumer choices, but that's a different, difficult measurement to take. And one may need to supplement that with qualitative evidences through consumer surveys, etc. May not be ideal because what you want is really reviewed preference instead of stated preference, but that's kind of one possible way to augment the traditional analysis. So one more thing, I think, in terms of indirect network effects that are present in the multi-sided platforms, I think, different schools of thought. Some people say you'll know it when you see it. That's probably true for a lot of the platforms, but for others, less so. And in fact, I think even the definition, what qualifies as a platform, is hotly debated as well. There's no one definition that everybody agrees on. So I think because of all this complications, when we analyze market power, market definition, I think a bright line approach might be leading to, we miss certain competitive forces that are at work here. So I think instead of taking a very simple, this is a platform, this is a transactional platform, we should do X, I think we take the same approach as what we always do, is ask the question, what are consumers' choices? What can they substitute in the but-for world in the absence of the alleged anti-competitive behavior? So if we keep those questions in mind, I think we will take whatever approach that is appropriate in that circumstance. And finally, I think it's related to the market definition, is the characteristic of a multi-sided platform of the asymmetrical pricing strategy. Sometimes, it's actually frequently seen is that on one side of the platform, you have zero or the subsidy sort of side, and then you've got the platform really making their profits from the other side of the platform. And the question becomes, because the antitrust policy goal is to protect consumer welfare through protecting the competitive process, then the question becomes, who are the consumers we're talking about? And whose welfare should be in that object function? And if I'm coming back to AMEC's decision, if one were go with defining one market, I think maybe both sets of consumers, their welfare should be considered in that objective function. But then it begs the question, could there be a surplus allocation? How do you weigh one side from the other? I think that's a really complicated question, challenging question. Probably not just economists should be thinking about, but also in terms of fairness, the enforcement agencies' thought on that would be greatly appreciated.
Thank you. SUWAZONO sensei, you mentioned briefly the Microsoft decision. And then also, I see Professor Choi, who worked on Microsoft's case when the KFTC investigated Microsoft back in 2005. I was there too. So I think in the history of the KFTC, the Microsoft decision was a watershed moment for the KFTC. They really established themselves as preeminent enforcer. So the way the KFTC is thinking about abuse of market dominance, most of them, they actually come from the Microsoft decision. So the leveraging theory, indirect network effect. I remember when KFTC sent out their initial examiner's report, they made a reference to spatial responsibility, just like in the EU. And then in the final decision, they actually took out the spatial responsibility because if they put in there, then other people may think that KFTC must have taken very strict form-based approach. So that way of thinking is deeply seated in the KFTC. So the fast forward, recently the KFTC take on the neighbor. Neighbor is almost a dominant player in the search market in Korea. We have a very different the ecosystem of the internet. And then KFTC challenged the neighbor for its alleged abuse of market dominance. They defined the relevant product market as a total market, so they determined the market share of neighbor is more than 70 to 80%. So it's almost like a super dominant. So once the KFTC determines the certain company under investigation is dominant, then it's very difficult to get away with their challenge in terms of the examination of the abusive conduct. So the KFTC took the decision against the neighbor, and then the neighbor took the case all the way up to the Supreme Court. And the Supreme Court overturned the KFTC decision by redefining the relevant market. The KFTC held that the market should be defined as market where the abusive conduct took place. So in that particular decision, the complainant was the online video content provider. So the KFTC didn't really care that much about how abusive conduct took place in this specifically delineated market. Rather, they actually defined the relevant market quite broadly. So KFTC is conscious of the unique nature of the multi-sided platform, but as long as certain company is very dominant and is super dominant, then of course they conducted economic analysis of the affected markets. They invited economists to opine on the competitive impact on the relevant market. But so far we have yet to see the case where the KFTC really has gone on as far as to assess the competitive impact on the relevant market. It's up to challenge. It's up to the KFTC to the sort of make their investment tool more sophisticated. Recently, the Korean Supreme Court in the Qualcomm decision, they actually instructed the KFTC to use more economic-oriented approach, just in line with European Court of Justice decision on Intel.
The speakers have all kind of talked about a number of very interesting features of two-sided markets. We've talked about market definition. We've talked about the issue of distribution of welfare. Oftentimes, seems to me that a lot of the complaints has the feature that some conduct benefit one side of the market, but may have some issues with the other side of the market, and it's very difficult to tackle these cases. So I would like to kind of go a little bit deeper into this and kind of have some discussion on what you think, how we should go forward in the sense of what are the practical challenges when it comes to either defense or prosecution or enforcement, and do you think there's a need to kind of have a rethink in terms of academic theory or economic theory that needs to be addressed to specifically to multi-sided platforms, and kind of more generally, it seems to me that at this stage, a lot of the competition focus is still on conduct. But if we look at the wider society, people are starting to think about whether there's something structurally wrong about tech industries. So I would like to hear some discussion on these several points.
Thank you very much, and it's a very good question. But before answering this question, and I'd like to say that so far, many panelists say that the many questions and the many challenging issues popping up in this industry. But I'm always saying that we should calm down. That it's not new things. Our existing tool can be applied to this new phenomenon. I think this is our enforcer's point of view. And also, I like to talk about just one example, which is, you're questioning about the two-sided market effects. And, 5 years ago, we faced a very big platform business, which has a strong two-sided market effects, especially indirect network effects. And this platform business, which especially focusing on the online video providing platform service, which has a 100% market share. And maybe most of you have never seen that the platform business. In Japan, that the so-called Duango platform business is a very unique because the viewers can post your comments or opinion on the screen, and other viewers concurrently, simultaneously view that comments. So you can communicate with each other on the screen, posting a comment or something like that. So you can concurrently share that communication. So it's a very unique service. So that it's a 100 market share. So this platform business tried to merge with other very big established publishing company, which has a lot of the video contents or other publishing contents or intellectual property assets. So that's why this merger will be created to conglomerate, big conglomerate companies. So recently the EU bestsellers, commercial bestsellers, 3 experts report say that we should care about the conglomerate effects of the platform business. So they try to entrench their platform business, core business. So we should care about that. But and of course, JFTC make econometric analysis by so-called Granger causality test and impulse response test, which shows that very strong indirect network effect. I'm not economist, so I cannot say about detailed things about the Granger test or impulse response test. But anyway, it shows that clearly indirect network effects was very huge. But on the other hand, JFTC decided to approve this merger without any conditions, because because of the strong indirect network effect. If they try to foreclose other video content provider, with a higher listing prices or something like that, if they do so, they lose their opportunity to get increased viewers, increased profit. So, because of the strong network effect, if you open to all of the various contents, you can increase the viewers. So that's why that sometimes strong network effects can bring the huge benefit to the consumers. Of course, having said that, in some of the if the platform business try to abuse this network effects to exclude other competitors, then it has a strong harmful damage to the consumers and also competition. But if this platform business try to be open to all of the various content providers, then it could be a very beneficial, very pro-competitive to the competition market. So, and also, 5 years passed, now we found that this our decision proved to be right, proved to be very appropriate, because this network provider always be open to the various content providers. So that's why that we should carefully take this network effect or other challenging issue very carefully. So that's why, of course, it's very challenging issue, but it's not dealing huge monster. Platform business should be treated by other, the traditional existing industries, companies. Thank you very much.
I'm trying to calm myself down. Sorry. So I'll just make a handful of observations here. First of all, so I think in direct response to the question, I think it's for certain types of platforms, if you in the U.S. apply an Amex standard, it's going to be harder for the government to prosecute, and it's going to be easier for parties to defend their conduct. Because I think pretty clearly, and again from all the nodding heads I saw, I'm assuming most people are familiar with Amex, the scope of liability for conduct post-Amex is narrower, at least under that case. Right? And it is, I think, more difficult for the government to show a but-for world where you're talking about harm just on the platform basis, right? And that's, I think, even more true in situations where you have only a single platform in business. So the more dominant, the larger a platform becomes, I think it's even more difficult for the government to make a case. Because again, under Amex, it's harder for them to show what the but-for world would be. So that's one observation. A second observation is that in that kind of a universe, an enforcement universe, it strikes me that what people are going to be focused on is looking at data, who controls data, because access to data can allow for for additional platform competition. It can facilitate platform competition. And the question then becomes, at what point do you start thinking about an essential facilities theory in the United States that applies to data? Right now, the law is very disfavorable to that in the U.S., but it's something that you might see, or you might see a regulatory solution, which I think is more likely, particularly depending upon how the election goes, the next presidential election. It might become more likely in a new administration that you have regulation dealing with data and pushing for things like data portability, or business could have data standards to allow for easier portability of data across platforms. So I think that's another sort of an observation of a particularized problem here that I think you're going to see going forward. And then the final one is, and I'm touching on a very broad topic, but it's nascent competition, and in particular M&A involving a large platform and a potential nascent competitor to that platform. So a head-to-head or horizontal acquisition. The FTC has gotten a lot of criticism, the US FTC has gotten a lot of criticism lately for Facebook, Instagram. So that was a deal the agency reviewed, I think 5 years ago. I was at the agency at the time. And without getting into, of course, that specific matter, people are criticizing the agency for not having seen into the future and saying that this is going to be, the Instagram is going to be the next sort of wave of social media. So the question that I would ask is, how can one see forward in a situation like that? What kind of tools do we have as antitrust enforcers, or what do antitrust enforcers, what kind of tools do they have to allow them to see into the future in that kind of a situation, and not get into the business of speculation? And I don't see an easy resolution to that. Either you create a bright line rule where you, for example, have no horizontal mergers of attention platforms, right? That could be your standard. I'm not advocating that. I'm just saying that's a bright line rule. Is that a good rule? Probably not. But the point is, I think that's an area where you're going to see a lot more work, and I think you're going to see enforcement around that area going forward, particularly in the U.S.
So one thing I thought maybe I'll start with is the difficulty of modeling what the competitive outcome would look like when you are dealing with multi-sided platforms. I think, the literature analyzes a monopolist or a duopolist, but under a lot of, assumptions. I think the situation gets even more complicated when you have one side of the platform actually competes with non-platform businesses. So I think things get pretty complicated, and there isn't quite a good benchmark at this point when you see, for example, certain kind of price setting where a platform sets certain prices on one side and versus the other. You couldn't quite have a good gauge of, okay, is that due to some kind of market power at work, or is it just simplest the platform is maximizing its profit? And I think it's relevant in the sense that, we've been talking about data, talking about empirical analysis. A lot of times when this kind of price setting issue comes up, a lot of times the plaintiff, the platforms generally say, well, we set certain prices to get both sides on board. We're improving the efficiency and improving the size of the pie of both sides' surpluses. So I guess, last year when the Court of Appeal in Europe ruled on Sainsbury versus MasterCard, in that case also is regarding the default merchant interchange fees. The merchants regarded the fees to be too high. And in that ruling, I thought one interesting comment is that the court actually specifically require not economic theory or anecdotal evidence, but rather data analysis, empirical evidence, truly tie the improvement in market efficiency to the alleged restriction, the complaint conduct. So I thought that was important things to keep in mind, especially in, we talked about all kinds of difficulties conducting such analysis. And I guess I'm not a lawyer, but I was always wondering, all this debate about the Amex decision, does it really have a lot of impact on the lower court's analysis when it comes to antitrust issues? Well, I was going to do a research, but it turns out somebody already done it. So I basically recently looked at one of the papers. They do not present it to be a comprehensive research, but through Westlaw, LexisNexis, they pull out the references of the Supreme Court decision and see why the case was referenced. And it turns out most of the references are regarding procedural issues or documentary evidence, production. It seems that the lower courts are still taking the approach of looking at sort of market efficiency, consumer welfare, and taking not such a bright line kind of approach to transactional platform do this, and non-transactional platform do something different. I think that's the right approach.
I'll be brief in the interest of time. As somebody who is on the defense side, it's always a challenge to persuade the captives to consider they need to consider the unique nature of the two-sided platforms. As you all know, the level of interdependence, between the multi-sides of the platform, they may either reinforce the dominance in the other side of the platform, or they can constrain the other side of the platform. But based on my limited experience in Korea, the regulator tends to look into sort of the reinforcing side of the platform. So it's a quite challenge, and the KFTC should think about how to improve the way they conduct the competitive assessment. And then one thing that really came to my mind is based on my the involvement in the Microsoft decision. When you take on this platform, I think you need to think about the remedies. what kind of the remedies should be put in place. In the buffer world, I think that what should be the right kind of the the ecosystem. As you know, after Microsoft decision, the Microsoft rolled out a Windows operating system without adjacent product like Windows Media Player. Only rare souvenir collectors, bought that one, and then just to relish the rareness of, there are only about 2,000, people who actually used this rare product. So I think that this, platform companies, if you look at the snapshot of the market, dynamics, then they may view it as dominant, but you need to think about what kind of remedies you can put in place. Thank you.
Thank you very much for all the very rich contributions. So as I was listening, I couldn't help but notice just how diverse the views are on the sufficiency or robustness of existing laws. And one thing that really strikes me in all the enforcement discussions on multi-sided platforms is what are the relevant bodies of laws, or what are the relevant policy goals that need to be in place at the forefront of policymakers and enforcers? Because truly, antitrust is only one dimension, as Alex alluded to. What about data? What are you going to do with data? And we didn't bring the big P word, which is the privacy word, into the panel today after our panelist discussions. But I was wondering whether the panelists would like to share your thoughts on, have we reached the limit of existing competition law tools? Have we really gone to the time where we need to think about new regulations? I think this is something that Alex was alluding to.
Yeah, thank you very much. Very good question. The consumer protection or data protection are the two of the source of the headache of our competition enforcers. Those kind of things are not jurisdiction of our competition enforcers. Previously, maybe several years ago, I didn't care about that. That kind of data protection and consumer protection issues. But now that they are the very big issue, challenging issue for competition authorities. And of course, we should demarcate that the jurisdiction of the data protection agency or consumer protection and our competition enforcers. I think that recently JFTC conducted market survey, which shows that clearly the consumers really care about the data protection issue as a matter of the competition policy issue. They are very they are very bounded by some of the conditions. They don't have any option but to comply with those, their data protection, data treatment condition imposed by platform businesses. So that's why that they care about that. They show. Our market survey shows that 80% of the consumers say that we really worry about that wrong treatment of the privacy or leakage of the information or something like that. So they suffer from that kind of things. And also, I'd like to talk about one very typical example. In Japan, also, the Facebook entered into Japanese market several years ago. But 1 or 2 years later, one big Japanese subsidiary of the Korean neighbor, which is so-called LINE, maybe in Hong Kong it's much popular than Facebook, and which is very popular in Japan, because much popular than Facebook, because Facebook is very notorious about the data privacy issue. They always treat the data to other third parties or something. It's not my comment. It's not my JFT's comment, but the personal, I heard that kind of stuff. But on the other hand, LINE service is a very, the more consumer-oriented service and data protection friendly service. That's why now the Facebook's market share is just 25%. On the other hand, the Line market share is 75%. So I think that that kind of treatment of the privacy is a kind of competition matter now. So that's why we should take care about this kind of things. But I think that it's a very big challenging issue for competition authority because we conducted a market survey. But is it just influential evidence for the court or something like that? I'd like to ask you, the economists, about these things. Anyway, it's ongoing question for enforcers. Thank you very much.
Yeah, I mean, my understanding of the U.S. Antitrust policy is that they do not regard privacy to be one of the issues that should be regulated or enforced through antitrust policies. Rather, it's probably something that needs to go through sort of the regulatory bodies. The way I look at data from an economist perspective is, a lot of times we look at data as a barrier of entry. If you are a first mover into the market and you get a lot of the customer browsing data, and I worked on the case where the company actually provides intelligent way to basically have the help chat box pop up on a website, and it's not timed. If you browse the website for example 5 seconds, and then the live chat box pop up, and that is a dumb way to do it. So supposedly, the client actually has 10 years worth of data where they run a call center and they can figure out where do people stop and when to intelligently pop up those live chat boxes. Those are, to me, a first mover advantage. And if you don't have that time period to accumulate that data, then you're behind. So from a competition perspective, I think any approach that will encourage the sharing of the data would help overcome that barrier to entry. Of course, then it runs into the privacy issue and the data protection issue, which we're kind of discussing right now. So I'm not sure that's quite something that will be that helpful, but
probably the Korean, the privacy protection regulation is more stringent, I guess, even compared with the European ones. Traditionally in Korea, the privacy is more like human rights, just like in Europe. So the level of enforcement on privacy regulation is very high. Some mass tort litigation took place some years ago, and then sometimes the Korea's Communication Commission took interest in the level of protection of privacy. So, in a way, they have a different sector regulator. So the KFTC tends, sort of, to stay away from their regulating privacy, with, their own tools. But, as you know, a couple of years ago, the Bundeskartellamt, made a decision. Of course, if you look at the decision, they have a very unique set of, legal framework under which they can, they actually impose, some sort of remedies, on the matter. But, regardless, they are interested. They're, conducting some, preliminary analysis. But, that's where you are. Again, just like in Japan, KFTC has different tools. Also, spring of bargaining position. So if they are not able to, pursue a certain case with the traditional framework, then they have other means of going after what they have in mind. So it's a bit more fluid situation, I guess.
Okay, so I'll make a couple of observations. I know we're running short on time. So first I'll say that I think that in the U.S. anyway, there is more and more of a consensus that at least for certain types of platforms, and I think primarily these sort of attention platforms, that the data that they are able to aggregate, that's typically, I think, volunteer data and observed data, that does allow them to maintain barriers to entry. It potentially enhances durability of market power to the extent that they gain market power. I do think that that's becoming more and more the view, and it's becoming discussed more prevalently in the U.S. And the answer to that, the solution to that, I think that people are beginning to talk about is really more of a regulatory solution. Again, one that would promote data portability, or that would incentivize businesses to create data standards to allow for sharing of data or movement of consumer data across platforms. There is, of course, the proprietary interest that the platforms may have in some of the data, like inferred data, which is a form of data that they actually generate internally. And so that's something that would also have to be thought about and dealt with probably through regulation. So that's just building on the earlier points regarding data. And then I think, so I'll close it out maybe by saying that in terms of blending antitrust and privacy, I think that there's going to be a lot of resistance to that in the U.S. I think that the agencies typically still have the philosophy from, if people are familiar with the Google DoubleClick case from about 10, 12 years ago, where the FTC declined to intervene on the basis that Google and DoubleClick, two online ad companies, obviously, that combining their data sets would create privacy issues that would incentivize them to violate people's privacy. The FTC was encouraged to pursue that deal on that basis and declined to do that, saying it was beyond its authority under the FTC Act, under the unfair methods of competition prong of the FTC Act. I think that's still the prevailing view in the U.S. I've certainly gone on record saying that if you do blend privacy and antitrust, except in circumstances where privacy is an existing dimension of competition, that you risk destabilizing antitrust doctrine by injecting unnecessary subjectivity into the analysis, and that's going to create problems over the long term for antitrust doctrine. I think that generally speaking, the traditional antitrust tools are going to be sufficient for purposes of dealing with most of the problems that we encounter here and that we've discussed today. You probably are going to need tweaks to those tools over time to deal with some of the issues that we've discussed. And one of them might also be defining the consumer welfare standard and offering a better definition of that. People talk about it, they debate it, and yet there really isn't sort of a single definition of consumer welfare. So anyway, that might be a good place to start. Very simple. Thanks.
Thank you very much for sharing your thoughts with us. I think we still have 6-7 minutes. Maybe it's a good time to have Q&A. Questions from the audience?
It's not a question, but today in the introductory remarks by Hongbin Kai, he complained that actually we are dealing with only number 2 issue. So number 1 issue becoming trade. And actually I'm going to combine a platform competition and the trade issue together and to make this one a super number 1 issue. So we talk about the privacy issues, and many different countries have a different privacy regulation. And my question is maybe this kind of a different regulatory policy on privacy can be used as a disguised form of a trade policy, or maybe unintentionally, maybe it can impact trade across countries. That's something we need to think about. Fragmented data market structure may have some implications for international trade and efficiency.
Thank you.
Thank you very much. Very good question. I'm not trade people. I'm not trade person, but I can say that now that some of the existing trade negotiation, trade framework, like TPP 11, or now that the new NAFTA treatment, have some kind of the digital economy chapter, which has some kind of privacy protection treatment rule. So that's why these kind of rule could be universally adopted by some kind of regional trade agreement. So that's why maybe, of course, some of the countries adopted different rule of the privacy treatment or something like that. But maybe internationally, those rules could be converged into one standardized rule, I think. That's my answer. Thank you.
The privacy issue is a very important in international trade discourse right now, as you know. In the CPTPP, which came into force, as you know, and then USMCA, among 3 different companies, they have a separate chapter on digital trade. But one of the central questions in the context of the trade discourse was not really about how to protect privacy. It's really about the data transfer. So the data-heavy platform companies, they're very much interested in how to make sure that they can fully transfer the data. For example, in the course FTA between the United States and Korea, one of the issues they discussed intensely was, especially in the financial sector, how to make sure that the U.S.-based companies with a big database can collect and process the data outside of Korea freely. In order to process the data, you need to have the data from Korea. So what the U.S. has in mind and is pursuing is to make sure that data transfer should be freely available, so that they can have a better system where all the companies, without having to localize the facilities, there will be more efficient society in their view.
I'd like to ask a question about data and essential facility or essential facility doctrine. In mainland China, has been hotly discussed whether or what kind of data should be regarded as essential facility. I'd like to hear maybe some views or debates in different jurisdictions.
Well, I think in the U.S., the essential facilities doctrine originated more than 100 years ago, I think, with the U.S. v. Terminal Railroad. That involved the physical structure. Again, I see nodding heads, so I think most people are familiar with it. And so I think within the U.S., there is still, until Trinco, a lot of people assume that the essential facilities doctrine was a viable doctrine in the U.S., particularly as it related to physical assets, right? Because it would be economically irrational to force competitors that needed a physical asset to build, in certain circumstances, a second physical asset in order to compete, right? It's economic waste. Since Trinco, of course, the doctrine has been called into question in the United States, both with respect to physical assets and then also with respect to data. There are a number of cases that have been debating whether or not the essential facilities doctrine should apply to data. My own view is that I think it'd be very difficult to do that. I think you'd have to find an incredibly unique data set that is something that is not otherwise replicable. So you'd have to find something that, most data tends to be non-rivalrous. It tends to be non-exclusive. You're able to build a data set if you want to compete with someone, at least within a reasonable frame of time. So I think it'd be hard to apply the essential facilities to data, both from the standpoint that under U.S. law, it's unclear and I don't think favored right now. And then also from a practical standpoint in dealing with data, in most circumstances, it's hard to show that a data set is truly unique in the way that a physical structure was, 100 years ago when the doctrine was originated.
Thank you. Stephen Mann, head of legal for APAC at eBay, and I have a question that's related to data, and it's not particularly directly involving the end users, but between platform companies. And you've mentioned that a number of the big companies have multi-disciplines now. typically starting off with digital advertising, and many have moved into marketplaces as well. The companies like ours have very few channels to advertise our services and need to work with some of the giants. And I don't need to name the usual suspects here. I think there are a few representatives in the room. But I just want to hear from the enforcement standpoint or from industry, if regulators are alive to the issue of provision of data for the use in advertising, and that potentially being misused when they go about building out their marketplaces, and whether there's an appetite to look into that, and if not, maybe there should be, as competition is fierce in this space.
Thank you very much. Very good question. A very difficult question to answer very quickly, but just a limited time. But having said that, in Japan, that the Facebook firstly entered into the Japanese market, and it had a lot of data about advertising and other things, and of course personal data. But 1 year, 2 years later, Korean subsidiary company entered into Japanese market. They pass over the Facebook. They got 70% or 80% market share. So I think that the multi-homing or the single homing is a very good issue to solving this kind of issue. Maybe we should be very careful to deal data set as a essential facility. I think that some market platform business can survive. Facing very big businesses, but of course, sometimes big businesses try to exclude the competitors by utilizing the data set. Allow that some of the counterparts to not to contract with the other new entrant company or something like that. So maybe enforcers should more and more closely monitor that what's happening. So if you have some kind of complaints in Japan, please ask me. Thank you very much. Okay, thank you.
Thank you very much, everybody. In the interest of time, I think we should break up for coffee. Before we break up, let's give the speakers